Welcome back, ladies and gentlemen. We will conclude today's program with a virtual hearing demonstration. This demonstration will be divided into two segments. The first segment will be the cross-examination of factual witnesses, and the second will involve a hot tubbing of expert witnesses and cross-examination of a tribunal-appointed expert. For the first segment on cross-examination of factual witnesses, the tribunal will consist of Dr. Eun-Young Park, member of the SIAC Court of Arbitration and co-chair of the International Arbitration and Cross-Border Litigation Practice at Kim and Chang. Dr. Park will be the presiding arbitrator. His co-arbitrators will be Mr. Arthur Dong, partner at the AnJie law firm, and Mr. Prakash Pillai, partner at Clyde & Co. Clasis, Singapore. For the second segment, the hot tubbing of experts, the tribunal will consist of Mr. Stephen Lim, arbitrator and barrister at 39 Essex, Singapore. Mr. Lim will be the presiding arbitrator. His co-arbitrators will be Mr. Craig Celniker, head of international arbitration and Asia dispute resolution at Morrison and Foerster, and Mr. Kop Yu Kevin Kim, senior partner at Peter & Kim. Counsel for claimant will be Ms. Sheila Ahuja, partner at Allen & Overy LLP, and Ms. Elodie Duloc, partner at King & Spalding. The counsel for the respondent will be Mr. Andre Yap, SC, senior partner and head of international arbitration at Raja & Tan Singapore LLP, and Mr. Alistair Henderson, managing partner for Southeast Asia at Herbert Smith Freehills. Claimant's factual witness will be Mr. Daniel Allen, foreign lawyer at the Mori Hamada and Matsumoto Group, and respondent's factual witness will be Mr. Robert Wachter, co-head of international arbitration and cross-border litigation at Lee & Co. Claimant's expert witness will be Mr. James Nicholson, head of Asia Economic and Financial Consulting at FTI Consulting. And respondent's expert witness will be Mr. Ian Potter, partner at MDD Forensic Accountants. Finally, the tribunal-appointed expert will be Mr. Andrew Webb, managing director at the Berkeley Research Group. I will now hand it over to the tribunal, please.
Good afternoon, ladies and gentlemen. This is the evidentiary hearing in the case of a claimant, Plymouth Coal and respondents, Republic of War and Peace and Kingdom Mining Development Corporation. My name is Eun-Young Park, and I am the president of this tribunal. I am joined by Mr. Arthur Dong and Mr. Prakash Pillai as co-arbitrators. As you see, we are joining from all over the places. While the tribunal has a power to hold a hearing virtually under the SIAC investment arbitration rules, I would like to know if either party has any objection to this virtual hearing. Claimant counsel?
Mr. President, no objection on the part of claimant.
Thank you very much. Respondent counsel?
No objections.
Thank you. As I have already addressed in the procedural order, my associate, Mr. Junhak Chae, is serving as a tribunal secretary. I understand, but would like it confirmed. There is no objection to this on the part of the either side.
No objection, Mr. President, on our side.
Thank you.
No objection on the respondent side too.
Thank you very much. We have an order as agreed between the parties. Counsel would like to give an opening submission, which would be followed by witness examination. Right? Claimant counsel, Ms. Ahuja, now you have a podium.
Thank you very much, Mr. President and members of the tribunal, my opposing counsel. Good afternoon, everyone. I appear for the claimant. Before I commence the substance of my oral opening, I have two short points of procedure to raise. The first is that the time allocated to me is a mere 5 minutes, and much as I will try and keep to this time, Those who know me know that exceeding time limits has become a particular forte of mine. And so I would request that I be allocated a little bit longer, say 10 minutes or thereabouts in opening, such that the excess time may be deducted from my cross-examination later on. And of course, if my opposing counsel suffers from a similar strength, I have no objection to him following the same approach on time allocation, subject always to the tribunal's view. Second, I will proceed on the basis that the tribunal is familiar with the basic facts relating to the dispute, but I trust that the tribunal will let me know if I'm wrong to do so. With that, let me start with 3 key matters that are not disputed in this case. First, the claimant, my client, duly performed its obligations under the agreement in question and completed the construction of the iron refinery and smelter in the first respondent's territory. Secondly, that in breach of the agreement, there was a failure by the respondents to supply the monthly iron ore to the claimant for the months of March, April, and May of the year 2020. And thirdly, as a result of the respondent's breach, claimant was unable to commence operations and has suffered significant loss, although of course the parties disagree on the exact quantum of that loss. So the only area of dispute really, and thus the only issue for the tribunal to determine, is whether, despite the respondent's breach and the claimant's loss, the respondent should be allowed to avoid liability as a result of the COVID-19 pandemic, which I say as an educated guess the tribunal will be well familiar with. And to this end, the respondent relies on a single clause in the agreement, the force majeure clause, or if I can use shorthand, the FM clause. Now I'll come back to the wording of the clause and the FM events relied upon, but 3 propositions should be made here which relate to the respondent's reliance on that clause. The first proposition is that, of course, it is the respondents who bear the relevant burden of proof, and to the extent that there's any ambiguity, it must be resolved against the respondents. Second, there's no magic to COVID-19. The question of whether each of these 3 events relied upon by them does amount to an FM event under the agreement must be assessed in accordance with ordinary principles of Singapore law, and that is the law that governs this agreement. The alleged link to COVID-19 itself does not justify any special treatment that takes us outside of that remit. And third, as found by the Singapore Court of Appeal in the case of Wholesome and Precise Development, which cited with approval another case of RDC Concrete and Sato Kogyo, and I'm citing here from the Court of Appeal, the most important principle with respect to force majeure clauses entails simultaneously a rather specific factual inquiry. The precise construction of the clause is paramount, as it would define the precise scope and ambit of the clause itself. The court is in accordance with the principle of freedom of contract to give full effect to the intention of the parties insofar as such a clause is concerned. So unlike in some civil law jurisdictions, the freedom of contract and not any public policy is the principle at play here. And on this last point about the FM clause in question, the respondent's position, reading from the case outline, is that a pandemic, COVID-19, was intended by, well, not COVID-19, but a pandemic was intended by the parties to be included in the scope of the FM clause during the pre-contractual negotiations, and therefore it has not breached the contract. In other words, and perhaps cognizant of the weakness in its case relying on what is in the contract, the respondents seek to rely on pre-contractual evidence to widen the scope of the force majeure clause. Now, it is in response to this that I make my first point, which is a short one, and that is that pre-contractual evidence relied upon the respondents ought to have no bearing at all on the tribunal's determination. There are 2 provisions in the SIAC investment arbitration rules that come into play here. The first is Rule 16.2 of the investment arbitration rules, and that provides that the tribunal shall determine the relevance, materiality, and admissibility of all evidence. The tribunal is not required to apply the rules of evidence of any applicable law in making such determination. The second applicable rule is 28.1, which provides in relevant part that the tribunal shall apply the law or rules of law designated by the parties as applicable to the substance of the dispute. Now, members of the tribunal, what this means is that although the questions of relevance, materiality, and admissibility of evidence are matters within the tribunal's discretion, without the necessary application of any particular rules of evidence, the question of whether the construction of the FM clause here should be impacted by the extrinsic pre-contractual evidence is still one for Singapore law, which is the express choice of law of the parties. Turning to the relevant principles of Singapore law, what we say is that first, any extrinsic evidence must always go towards proof of what the parties from an objective viewpoint ultimately agreed upon. Evidence which only goes to a party's unilateral or subjective intention or understanding should have no bearing on the interpretation of the contract. Secondly, extrinsic evidence cannot contradict or vary the express terms of the contract in question. The effect of that extrinsic evidence is therefore limited to explaining or illuminating the express terms. And this is a point confirmed again by the Singapore Court of Appeal in the case of Zurich Insurance and B Gold in 2008. So with that background of the principles, what the tribunal will find is demonstrated over the course of the hearing is that the pre-contractual evidence that the respondents seek to rely on does not demonstrate the common intention of the parties as objectively ascertained, and in any event cannot distort the express wording of the agreement that the parties have agreed to and have the effect of transforming a non-FM event into an FM event. And it's for that reason that I say the evidence here, the pre-contractual evidence, should have no bearing, ought to have no bearing on the tribunal's determination. That takes me...
Yes. Ms. Ahuja, sorry to interrupt you, just a very quick question. I was just waiting for a little while for you to explain something you had said earlier, but I don't think it was forthcoming, so I think I should interrupt you here. Earlier you said that, if there's ambiguity in a clause, it should be construed against the respondent. Perhaps you could let us know your legal basis under Singapore law for making that point. Thank you.
Certainly, Mr. Pillai. So the case that I cited, the RDC and Sato Kogyo case of the Singapore Court of Appeal, deals with force majeure clauses, and on that basis actually says, and I'm reading expressly from paragraph 80, that where a party seeks to rely on a force majeure clause, the law places a burden on it to satisfy the court that it falls within the scope and ambit of that clause. And so therefore, what we say is that if there's any ambiguity in the party who's seeking to rely on that clause, if there's any ambiguity in that clause, then that must be construed against the party that's seeking to rely on it, because it's consistent with the burden that falls on it for it to discharge.
Thank you.
I'm grateful, Mr. Pillai. And that takes me to my second submission. My second submission relates to the construction of the clause itself. Now, in short, the respondents must satisfy two conditions with regard to each alleged force majeure event. And in my submission, as may not be surprising, neither condition is satisfied in respect of any of the alleged events. So let's start with the FM clause again. And this time, if I may ask you to look at it, and the best place to look at it is in Mr. Tolstoy's witness statement at paragraph 16. This version that's extracted here, and members of the tribunal, you may see many iterations of this, and some of them are in draft, but the final agreed, expressly agreed written version is here at paragraph 16. And what it requires is two things, as you read it, if I may invite you to establish. First is that the respondents must establish that each of the alleged FM events was beyond the reasonable, direct, or indirect control of respondents, and without the fault or negligence of respondents. Secondly, and additionally, the respondents must prove that each of the alleged FM events resulted in their ability, partially or fully, notwithstanding its best efforts, and I'll come on to this, to perform its obligations in whole or in part. Now, the term inability, just focusing on that second condition there, the term inability means that the respondents must prove that they were prevented from and not merely disrupted or hindered in performing their supply obligations under the agreement. In other words, the respondents must demonstrate that their performance was made legally or physically impossible and not just difficult or unprofitable. And here again, if I may cite the Singapore Court of Appeal from the same case that Mr. Arbitrator, well, as a result of your question, I went to the RDC and Sato Kogyo case, that this is merely an extension of the general principle that a party must be strictly held to its contractual obligations and should only be released from them where supervening events make it impossible and not merely onerous to fulfill them. Likewise, the requirement of best efforts is also onerous and more stringent than the simple reasonable efforts that are found in many other FM clauses, not this one. And what I say is that it requires the respondents to take all steps, and again, I'm citing from a Singapore case here, that a prudent and determined man acting in the interests of the obligee, and here the claimant's interests, and anxious to procure the contractually stipulated outcome within the available time would have taken. So applying the construction of the FM clause to the facts, and I'll try and do this quickly, I'm conscious of my time here, the respondents rely on 3 alleged events, but in my submission, it's clear that the respondents have failed to satisfy the conditions prescribed in the FM clause that I just took you to with respect to each and every one of these 3 alleged FM events. Now, first, the respondents rely on the decreased workforce due to COVID-19. But to that we say the decreased workforce was not an event beyond the reasonable control, beyond the reasonable direct or indirect control of respondents, and without the fault or negligence of respondents. Now, this is because it resulted from the respondents' inability to reach a compromise with the labor union for almost 3 months, and its own failure to put in place any alternative arrangements in the interim. Furthermore, and in any event, the respondents cannot establish that they have used best efforts to perform their obligations in whole or in part. And I say to that, obviously, alternative arrangements could have been made. In fact, the labor union's own recommendation was to cut the shifts by half. But the second respondent failed to arrange any employee to perform their supply obligation to the claimant for almost 3 months. And that, we say, doesn't fall within the requirements, doesn't satisfy the test. Second, the respondents rely on the restriction on mining activities as a result of the government-enforced COVID-19 measures, in other words, the lockdown, declared by the President of the Republic of War and Peace. However, 3 short points here. First is as a matter of timing. This alleged FM event cannot excuse the respondents' failure to supply the first batch by 1st March 2020 because the lockdown only began on 25th March. So it's a mere temporal point here. But putting that to one side, the second point is that despite the lockdown, the respondents still need to establish and have failed to do so that they've used their...
Sorry to interrupt. I'm mindful of the time. I appreciate your presentation, but for the sake of fairness, your overrun time has to be considered in your time cross-examining new witness. So bear in mind that. Thank you.
I'm grateful, Mr. President, and I hope I shan't be more than a minute when I look at the clock myself. The point is that the lockdown could not, by definition, be an event beyond the reasonable or indirect control of the first respondent. The respondent did have a choice as to what measures to adopt in response to COVID, and although it was a difficult choice, the existence of the choice means that it wasn't impossible to, of course, take it into account. And thirdly, the supply chain disruptions resulting from the lockdown meant that the respondents were unable to replace parts of their machinery that rendered these machines unsafe. But of course, they failed to establish that there was indeed an absolute lack of supply, i.e. there was no alternative supply, and that they could not have replaced the alleged parts before the disruption. And of course, they couldn't also establish the duration of this force majeure event. So in my second submission, none of these 3 points, these factual events that the respondents seek to rely on, have any merit when looked at against the construction of the FM clause. So all in all, my point, members of the tribunal, is that the respondents cannot be allowed to renege their contractual obligations unless they can prove that the precise wording of the FM clause protects them. And here, it doesn't, and they can't rely on anything outside of that contract. And that's all I have to say. I do apologize for overrunning in making those submissions.
Thank you very much. Mr. Yap, please.
Sorry, allow me to commence by giving an overview of the respondent's case. Our case is indeed a straightforward one, a straightforward case, a straightforward submission for a very straightforward case. The case turns on the interpretation of the force majeure clause. It is the claimant who has somehow sought to alter the meaning of the force majeure clause. Our position is simple. We fall within the language based on its plain and ordinary meaning. And in this respect, it is not the respondent who is trying to seek to rely on pre-contractual evidence. It is the claimant who is seeking to do so. And based on that approach, the claimant is seeking to actually alter the meaning of the plain and ordinary words that we see in the force majeure clause. They are trying to distort the meaning, and they're trying to do it by relying on pre-contractual negotiations. And in that respect, they are seeking to do so by saying, well, there was a first draft of the agreement, and the first draft comprised subparagraphs A to I, and they wanted it deleted, and the respondent agreed to the deletion. And embedded within subparagraphs A to I is subparagraph E. And subparagraph E specifically made reference to epidemic, cataclysmic events, and quarantines. And those were clearly part of the included language, because the definition is set out in the force majeure clause, and it goes on to say including A to I, and of course that includes subparagraph E and reference to epidemic, cataclysmic events, and quarantines. So with all due respect, we say we are relying on the plain and ordinary meaning as set out in the force majeure clause. The respondent's case essentially is that we were caught in a storm. We were caught in a huge COVID storm. That is a pandemic, an epidemic, a cataclysmic event. It was involved with quarantines, lock, stock, and barrel. And this was well into effect even before 1st of March. It continued past 1st of March. And indeed, it is the result of the epidemic that the presidential lockdown orders were made. And we know there were 2 presidential lockdown orders. And basically, they cover the period from the 25th of March through to the 24th of May. So there are 2 points that I want to highlight really in relation to the presidential lockdown orders. First is that clearly they evidence the fact that there was an epidemic, a pandemic, a huge COVID storm. As we all know, governments are reactive. The epidemic has to strike. The government has to do its investigations, does its homework, decide what measures need to be taken to protect its people, and then enact the relevant legislation. So even before the first presidential lockdown order was made, the epidemic was in force. The lockdown orders ended on the 24th of May. But that didn't end the epidemic. It doesn't mean just because a presidential order for a lockdown says this goes on till the 24th of May, that on the 25th of May, like SARS, somehow the COVID-19 germs disappear, evaporate, and the world becomes safe. That is not the reality. The reality, as we all know, is that the COVID storm, the COVID epidemic, pandemic, continued well beyond 24th of May. Why the government did not extend its lockdown? There are various issues for that, but certainly our position will be that it does not mean that the pandemic was at an end. And certainly we say that the COVID epidemic was operative in full force throughout the months of March, April, and May, which is the relevant period of the claimant's claim. I also want to say that the claimant has taken the position that parties had agreed to narrow the scope and meaning of the force majeure clause. With due respect, we will certainly submit and demonstrate in the course of cross-examination that this is far from true. The reality was that the claimant was highly concerned that subparagraphs A to E, all or at least many of those subparagraphs appeared to be related to mining incidents, or if not then, to local events. As a result of that, they wanted to ensure that subparagraphs A to E did not exist for purposes of trying to limit the scope of the force majeure clause. And it was with that purpose that they sought the deletion of subparagraphs A to E, which the respondent agreed to. But in no way was it ever intended to narrow the scope of the force majeure clause. Unless the tribunal has any further questions for me in relation to the opening, I would be happy to follow up in cross-examination subsequently.
Thank you, Mr. Yap. Now we are going to hear from the witnesses. Is Mr. Victor Wigo present here?
Hello, I'm here.
Mr. Victor Wigo, you will be heard as witness, and therefore, on behalf of this tribunal, I invite you to state the truth and nothing but the truth. In order to make this a binding commitment, please say, I confirm.
I confirm.
Thank you. Mr. Yap, you have a witness for cross-examination.
Mr. Hugo, well, I noticed that you're the CEO of the claimant. That's correct, isn't it?
Yes, that's correct.
I'm just curious, does anyone call you Hugo Boss for that matter?
That's a great idea.
Anyway, let's go to something more serious. And let me come direct to the chase. Do you recall any particular correspondence, essentially, where you might have stated that the force majeure clause was too specific to mining operations?
I recall that I had some correspondence about the negotiation of the contract. If you're asking me about a specific piece of correspondence, I would be grateful if you could show me which correspondence you're referring to.
Yes, but before I do that, let me perhaps just refresh your memory in relation to a particular statement and give you every opportunity to clarify that statement. And I'm looking at paragraph 22 of your witness statement. You have that? In paragraph 22, you have stated that I note that parties agreed to narrow the meaning and scope of the force majeure event. You see that?
I see it, yes. So I have it on my screen, and now I'm seeing it on this screen as well. Yes.
Now, I take it that you are making this statement based on the deletion of subparagraphs A to I, which existed in the first draft of the agreement.
That's correct.
Do you still stand by this particular provision that you have built into your witness statement?
If you mean, do I stand by paragraph 22? Yes, I do.
Very well. Now, let me ask you to look at tab 2, which is your
Thank you.
letter of 11th May to Mr. Leo Tolstoy.
Yes.
And if I may invite you to look at subparagraph 3. Do you have that?
Yes, I'm reading it now.
You have stated that the force majeure clause is too specific to mining operations. Please see amended clause as attached. The
That's right.
amended clause as attached is the same force majeure clause, except the word deleting, the word including in the main paragraph is deleted, followed by deletions of subparagraphs A to I. Correct?
I don't have that document in front of me, but I believe what you're saying is correct.
So isn't it the case here, Mr. Hugo, that you were concerned really that some, if not all of these subparagraphs were somehow linked to mining operations?
No, that's exactly right. We were concerned that if there were a list of potential force majeure events that were specific to mining, then anytime anything that had anything to do with those specifically listed events, it would be very difficult to have a constructive conversation about whether really it were force majeure or not. We wanted to have a clause that required a general force majeure event of a very significant nature. So that is why we wanted to delete the list.
Well, actually, if I could ask you to look at the list of events listed in the draft, and this is, in fact, you can just look at paragraph 18 of your own affidavit, of your own witness statement. If we look at subparagraphs A, D, F, H, and I, these are matters, if you look at, appear to be directly related or arising from matters which would impact the ability to carry on mining operations.
Yes, I agree.
And in fact, even if we looked at B, C, and G, subparagraphs B, C, and G, they could also possibly impact mining operations.
I certainly agree.
So wasn't your concern really then that somehow the force majeure clause as drafted might be possibly restricted under the powerful arguments of a formidable litigator to try to say that somehow the force majeure text, the main text of the force majeure provision was limited, intended to be limited to mining related incidents and would exclude non-mining related incidents?
Sir, if I may take a moment to respond, I think the nature of your question has helped to kind of clarify what's going on here. You've approached this from the perspective of a lawyer, but I'm a businessman. I'm the CEO of a company and I'm not a lawyer. I can tell you how this stuff works in practice. If there's a long list of potential force majeure events in a contract, then the parties, when one of those events happens, argue about whether it fits within the scope of the list rather than talking about the broader impact of the event and whether it's a very serious event. What happens is in practice, and this is what really happens in business, is that something happens that looks a little bit like one of the events on the list, but it's not that serious. Nonetheless, because it appears in the list, we have to talk about whether it's a force majeure event. That's not what we wanted. We wanted to get rid of that. We wanted to get away from that. And so I appreciate that there are legal arguments around this, and the way you look at this is, yeah, it's a very skilled litigator might argue X. I don't think like that. I think about what's going to happen in my business.
So the reality was that you didn't want a situation where an incident could be simply described as falling within subparagraphs A to I, and therefore try to claim that the force majeure event had occurred.
What we didn't want was a minor event that bore some resemblance to something that appeared in the list being characterized as a force majeure event when really we knew it wasn't.
So really, you were not seeking in any way to narrow the scope of the force majeure event. In reality, no. You were looking to make sure that it was not being limited by subparagraphs A to I.
Again, that's not really how we see it. If we're trying to limit the scope of the clause, what we're talking about there is limiting it to exclude stuff that isn't very serious. And so removing the list helps us to do that in practice.
Now, let me also ask you this question. Do you recall that you had a phone call with Mr. Leo Tolstoy where you told him that the second, you told him essentially that the examples listed in the draft force majeure event clause could fall under the force majeure clause without much difficulty, or words to that effect? Do you recall that?
I had a number of phone conversations with him. If there's a specific conversation you mean, I think it would be helpful if we could kind of talk about it in more concrete terms. I have my recollection. I'm sure that he has his. I haven't seen his testimony, so I'm not sure what exactly he's saying.
Well, Mr. Hugo, please look at tab 3 to your affidavit, to your witness statement. And this is a letter from Mr. Leo Tolstoy to you. It's dated 25th of May. And you exhibited this letter. Please look at the 4th paragraph. As you mentioned during our call on Wednesday, the examples listed in the draft agreement could fall under the amended force majeure clause without much difficulty. And the preceding paragraph makes clear that the subject matter here is the discussion in relation to the force majeure clause comprised in the earlier draft, which you had sent. So coming back to the 4th paragraph here, where Mr. Leo Tolstoy said that you mentioned during our call that the examples listed in the draft agreement could fall under the amended force majeure clause without much difficulty. Now, Mr. Hugo, nowhere in your affidavit do you exhibit any response on your part denying that you had said this. You accept that?
I'm sorry, what exactly is your question?
My question is this: nowhere in your witness statement do you set out any correspondence denying that you had said to Mr. Leo Tolstoy what is contained in paragraph 4 of that letter in tab 3.
That's right. I didn't write back to him saying you're wrong.
And neither did you say in your witness statement that this statement is wrong. You accept that?
I don't think I need to say that. but you're right that that's an accurate characterization of what's in my witness statement.
And presumably, there is no correspondence denying this call and what was said on this call as set out in paragraph 4 of tab 3.
No, we were happy to move on from that issue.
Allow me to finish my question.
Of course, Counsel.
There was no correspondence denying this, and there is nothing said in your witness statement to the effect that this is not true, because what Mr. Leo Tolstoy has said here is the truth, and correct.
No, that's not correct.
Now, if this was not correct, surely you would have, at the relevant point in time, sent a piece of correspondence to say, I didn't say this. Please don't put words into my mouth, or words to that effect. You didn't do that.
No, I did not. Will you allow me to explain?
I don't think that's necessary. And again, even if you had somehow missed it then, surely you could have put it into your witness statement that you didn't agree if you thought this was inaccurate or untrue.
Once again, I didn't think it was necessary.
I am putting it to you, Mr. Hugo, that you did say to Mr. Leo Tolstoy that the examples listed in the draft agreement could fall under the amended force majeure clause without much difficulty. You may either agree or disagree with it.
I disagree with that.
Honorable members of the tribunal, I believe that I have substantially utilized my time for cross-examination, and I propose to leave it as it is at this stage.
Thank you,
Unless
Mr.
the tribunal has any further questions for me.
I have a question, Mr. Yap, for you, a very quick one. This is in relation to a comment you made about the claimant's case, and I think you criticized the claimant for relying on pre-contractual evidence in order to interpret the contract. You made a point about that. But I noticed that the respondent's witness affidavit or witness statement, there are a number of paragraphs that deal with pre-contractual evidence. Your entire cross-examination was entirely on pre-contractual evidence. So, maybe you can enlighten the tribunal as to where you stand on pre-contractual evidence and how we should rely on pre-contractual evidence, if at all. Thanks.
Well, I think it's clear that in terms of tenets of construction, the first approach is to look at the relevant provision and see what it means. And certainly on our case, we say you look at it clearly on the basis of what it says and give it its plain and ordinary meaning. There is no ambiguity to it, we say, and there is no necessity to refer to any pre-contractual negotiations or correspondence. If there is any ambiguity, then certainly it is open to the tribunal to look at the pre-contractual negotiations and the pre-contractual correspondence. That clearly is the rule under the Evidence Act and the interpretation rules. But of course, this being an arbitral tribunal, the Singapore Evidence Act does not apply. But there's no reason to depart from that very wise old approach in terms of the canon of construction.
Yeah, we'll consider that. Mr. Dong, do you have any question to the witness?
Yes, here's a question for Mr. Hugo. I would like to listen to your view that as a business people, so what's the difference between the force majeure clauses before and after your amendments?
Thank you, Mr. Arbitrator. The difference from our point of view was that without the list, it would be necessary if a party wanted to assert a force majeure event, it would be necessary for them to demonstrate that it was really a force majeure event and that they couldn't just point to an item in a list and say, it looks a bit like this, which we've already agreed is force majeure. My experience in business practice, and I've been at it a number of years, is that when you include a list of specific events, a party, when something that looks like one of those events occurs, will try to say that it's a force majeure event, even if it's not a very serious event. And that can be disruptive to business. I understand that the lawyers have a different view about how to interpret this and so on and so forth, but that's how it works in practice. And most of the time when parties talk about a force majeure event has happened, it never ends up in an arbitration like this. It's about working it out between the parties. And so we try to negotiate our contracts according to what's actually going to happen in our business.
Okay.
Right.
Yeah.
Go ahead. No. All right. I think that given the time, Mr. Dong, you have more questions? No. Fine. Okay.
Okay.
Let me finish and hear from another witness, Mr. Hugo. Thank you for your giving us as evidence. You are now released. Thank you.
Thank you very much.
Okay.
Now we are going to hear from another witness, Mr. Leo Tolstoy. Is he present? Mr. Tolstoy, we cannot hear from you.
I have my mute button off. Can you hear me now?
Okay. Mr. Leo Tolstoy, you will be heard as witness, and therefore, on behalf of the tribunal, I invite you to state the truth and nothing but the truth. In order to make a binding commitment, please say, I confirm.
I confirm.
Thank you, Mr. Tolstoy. Ms. Ahuja, you have a witness for cross-examination.
I'm grateful, Mr. President. Mr. Tolstoy, good afternoon.
Good afternoon.
Mr. Tolstoy, getting straight into your statement, if I may, and turning to the draft and final versions of the agreement in question, it was your lawyers who prepared the first draft of the agreement, correct?
That's correct.
And you provided the first draft to Mr. Hugo on the 20th of April, yes?
That sounds right. I think that's correct.
And in that agreement, there was a long form FM or force majeure clause, I call it FM for short, which had specific examples of force majeure events, yes?
Yeah, that's right. That's something that we'd used before. It had a list.
Right, and that's extracted at paragraph 14 of your witness statement. And I think it's being put up on the screen if you'd like to look at it. So as you say, Mr. Tolstoy, this clause was taken from another agreement, and it was specifically highlighted to you by your lawyers that it was extracted from a different agreement and inserted into this draft, correct?
That's right.
And Mr. Hugo suggested some amendments to this draft on 11th May, yes?
Yeah, I mean, he really wanted to simplify this.
Yes, and in fact, one of the amendments related to the FM clause, if I can take you to tab 2, which is appended to your statement, Mr. Hugo says at item 3, the force majeure clause is too specific to mining operations. Please see amended clause as attached. Do you see that?
I do see that.
Now, if I can go back and forth in your statement, let's go to paragraph 16 of your statement, which has the revised clause. And what we can see, Mr. Tolstoy, happened to it is that the examples have been removed, yes?
The examples have been removed.
And Mr. Tolstoy, you accepted that amendment, didn't you?
I did accept that amendment. I clarified the intent of it in a subsequent conversation, but yes, I accepted the amendment.
And as to that clarification, thank you for that. You say at paragraph 17 that your initial reaction to this was to call Mr. Hugo, who you said made a comment about how the examples listed in the agreement could fall under the amended clause. Is that right?
That's correct.
Mr. Tolstoy, is there a record of this alleged call?
Yes, there is. I sent a follow-up email after the call. I think the call was on May the 20th, and so on May 22nd, I sent a follow-up email. That's tab 3 attached to my witness statement.
Thank you. Mr. Tolstoy, we'll come on to tab 3 in a moment. What I mean, if I can clarify, is the call itself was not recorded or evidenced in any other contemporaneous form, correct?
I don't think that it was mentioned elsewhere. That's correct.
Thank you. And if you've seen Mr. Hugo's statement, you'll see that Mr. Hugo makes no mention of such call. Do you agree with that?
I'm not sure if he mentioned it or not.
Thank you. You can take it from me, Mr. Tolstoy, if the call did take place, is that those examples that were deleted could, rather than would, fall within the scope of the FM clause?
Yeah, I mean, the background, if I can explain, we wanted a list. He came back in his response and said, this is too specific. And so I understood that to mean that they wanted it broader, not just to cover the mining side, which would protect us, but protect them as well. But they didn't want to be specific. And so they wanted instead this language that anything affecting either party could potentially be force majeure. So I wanted to clarify on that call that didn't exclude anything that we had in the list. It just, we didn't go through the process of trying to identify every possible force majeure event.
Thank you. And Mr. Tolstoy, even in your words just now, it was that the events could fall within the scope of the FM clause. And so let's go to tab 3. I know you mentioned it a moment ago, which you said you sent after that call on the 22nd of May. So you said, and I quote from the 3rd paragraph, I'm okay to keep the force majeure clause brief and to remove the specific examples previously listed. Do you see that?
I see that, yes.
And of course, we've established that you were legally advised all along, that you had lawyers all along.
That's correct.
But you didn't, Mr. Tolstoy, suggest any other further amendments to the clause, correct?
That's correct on the basis of what we discussed.
Thank you. And Mr. Tolstoy, just a few more questions. Mr. Hugo never replied to your 22nd May email, correct?
He did not. That's correct.
Nor did he call you or in any way acknowledge that point that you made in there about how the examples could fall within the scope of the FM clause, yes?
There was no further communication on that point. That's correct.
Right. And you had the signing ceremony in your offices on the 2nd of June?
That sounds right.
Enjoyable? Champagne?
Caviar. Yes, it was wonderful.
Great. But no further words exchanged about this FM clause?
No further discussion on that clause.
So, Mr. Tolstoy, it is right to say then, is it not, that you and Mr. Hugo expressly agreed to a narrowly worded FM clause?
I would disagree with that. A shorter clause, but we think it was a broader clause.
But when you say we, Mr. Tolstoy, that intention wasn't common between you and Mr. Hugo, was it?
I can't speak for my good friend, Mr. Hugo, but on our side, that's how we understood it.
Mr. Tolstoy, isn't it true that although it may have been your intention that the examples could fall within the scope, the only evidence you have of that Mr. Hugo shared that understanding is an unrecorded phone call from you to him that he doesn't acknowledge and an email from you that he doesn't acknowledge or respond to? That's a fair summary, isn't it, Mr. Tolstoy?
I think that is correct. That identifies the evidence in the record that I've referred to.
Thank you very much for your assistance. Members of the tribunal, I have no further questions for this witness.
Thank you very much. Mr. Tolstoy, thank you for your evidence. You are released.
Okay. The question for the witness.
Oh, you have? Oh, I'm sorry.
Yes. Mr.
Okay, brief questions.
Brief question that Mr. Tolstoy. So in your view, is there a starting point of a force majeure event in this case? We noted that on June the 9th, your company provided the notice of a force majeure event. Is that the day the starting point of the force majeure matter in this case?
Well, the force majeure actually started back in February. There were 3 different events. One was the labor issue that came up in February. There was a second event in March when the government imposed the lockdown. And then we had problems on the supply chain that really affected the month of June. So it was those events individually and also in combination, but it all really started in February.
So you mean that even you sent the notice on June the 9th, but still the force majeure influence will go back to the February. Is that right?
That's right. I mean, we had notified them earlier informally on March the 3rd about the labor issue and the delay. We notified them on May the 5th of the problem that we were having with the government, but the formal notice we sent on June the 9th.
Do you think the informal notice could relieve your company of the liability of delay and incapable of carrying out the contract?
Well, I'll defer to my counsel to address the legal aspect. I mean, factually, we notified them of the problems we were having, and the problems just got worse and worse, and that's why we ultimately ended up sending the formal notice.
Okay, thank you, Mr. Tolstoy. I have no further questions to this.
Thank you very much, Mr. Tolstoy. You're free to go.
Thank you very much, members of the tribunal.
Thank you very much. I thank you for the counsel who have made this examination in good order. We will adjourn and we will regather for another session. Thank you very much.
Thank you, Chairman.
The tribunal will now proceed with the examination of the parties' quantum witnesses. We'll be hearing from Mr. Nicholson and Mr. Potter. Given that the parties have agreed a very, very strict chess clock for this hearing, the limited time we have, we will dispense, we've agreed we'll dispense with the formalities. Mr. Nicholson and Mr. Potter, you are both very experienced expert witnesses. You are fully aware, I'm sure, of your duties to the tribunal with regard to your evidence. The tribunal has reviewed your joint statement and your evidence. We would like to begin by just confirming the tribunal's understanding of the points on which you are agreed, and then we will ask you to comment on your points of disagreement. To begin with the points on which you are agreed, we understand that you both agree that claimants' losses should be measured as the difference between cash flow earned or to be earned as a result of the alleged breaches, which you call the actual scenario, and cash flow that should have been earned absent the alleged breaches, which both of you refer to as the but-for scenario. You both base your assessment of claimants' cash flow in the but-for scenario on claimants' management's projections of performance from 1st January 2020 to 31st December 2029. You agree projected cash flow should be discounted to present value, but you do disagree on the discount rate. You both assess the losses as at 1st of March 2020, the start date of second respondent's obligation to supply the iron ore. You agree on the factors that are to be taken into consideration in the calculations. These are the cash flows in the actual scenario, forecast steel prices, demand and sales volumes, operating capacity, and that you should also take into account a discount rate, both risk-free and country risk premium. However, Mr. Potter, you take into account all information available up to the hearing date, whereas Mr. Nicholson, you only take into account information available as at the 1st of March 2020. In other words, you both differ on whether hindsight information may be referred to, and this has led to the differences in the sources you consider available in addressing the factors that I've mentioned. Can I just ask you to confirm that this is an accurate summary of your positions?
On my side, yes, that's accurate, except that there may be other reasons for the differences between Mr. Potter and me than the hindsight point that you correctly summarized.
Thank you, Mr. Nicholson. We will hear from you on that shortly. Mr. Potter?
Yes, I agree. That's most of them.
Thank you. So just before we invite counsel to put their questions to you, we would then invite each of you to summarize your respective views on whether hindsight information may be referred to, and you may also comment on any other points of disagreement as you wish. You will each have 2 minutes to do so. We'll begin with Mr. Nicholson.
Thank you, Mr. President, for this opportunity. So on the point about hindsight, I've been instructed to assess losses as of the 1st of March 2020, as you correctly summarized, and that necessarily entails assessing losses based on facts and expectations as they were as of that date, the 1st of March 2020. If I were assessing losses as of a later date, then I would take into account events up to that later date, but I'm not. So from my point of view, or based on my instruction to assess as of the 1st of March 2020, I base my assessment on facts known as of 1st of March 2020 and expectations as of that date. I don't think there's anything else to say on that point. And you invited me to comment on any other disagreements, but I prefer to go through those one by one because I could go on for much more than 2 minutes if I started summarizing the disagreements, my views on the disagreements between Mr. Potter and me.
Right, thank you, Mr. Nicholson. Mr. Potter?
If we're going to restrict it just to the issue of hindsight, the starting point is I was instructed to take into account all information arising up to the date of this hearing. Stepping back from that instruction and thinking about what our instructions were more broadly to assess the losses suffered by the claimant in this case. If that assessment is to be made as accurately as possible, then it makes some sense to take into account all of the information available, particularly given the significant events that have occurred over the last 3 months and all the significant changes that have arisen in terms of operating capacities, steel prices, things like that during the last 3 months.
Does that conclude your preliminary statement, Mr. Potter?
If we're restricting to that issue, on a broader front, there is the hindsight issue. The other big issue between us would be the time period over which we calculate losses, but then we are going to start getting into the 6 or 7 points in our joint statement. So perhaps it would be easier if we do those one by one.
Right. Thank you, Mr. Potter. Then let's proceed to examination by counsel.
Mr.
Yes,
President, if I may, I don't know if this is within the format that you envisage, but I have a point to make in response to the point that Mr. Potter just made.
Oh, yes,
is it
please.
appropriate for me to make that now, or should? Yeah. So I fully agree with Mr. Potter that if we were assessing losses as of the present date or as of a date some months after 1st of March 2020, it would be more accurate to take into account the events that have occurred since the 1st of March 2020. But that's not the question I at least have been instructed to assess. I've been instructed to assess losses or the expectations, the value of the business as of the 1st of March 2020. And so it does not improve the accuracy of my assessment to take into account subsequent events. Those subsequent events are ruled out by logic, by the logic of the question.
Right. Thank you, Mr. Nicholson. Then let's proceed now with questions from counsel. We'll begin with Ms. Dulac.
Thank you, Mr. President. I'm going to start with a follow-up question on the instructions and the role of hindsight. Mr. Nicholson, you said you'd been instructed to take the date of the breach March 1st as a valuation date and not to take into account later events which became known after. Leaving aside your instructions, in your experience as an expert, without working on instructions, would you have taken the same approach?
Absent that instruction, I would have asked, what question would you like me to answer? And if I had no instruction or guidance as to that, then I would revert to economic first principles, which I understand in a loss assessment context to be to compare the position that the claimant would have been in but for the alleged breaches with the position it actually is in. And I would have assessed that, in fact, as of a current date. So I would have taken into account subsequent events.
Okay. But if you had instructions as to the date of valuation, March 1st here, you wouldn't have by yourself taken into consideration later events in assessing valuation date of March 1st.
That's right. I think I was only instructed to assess losses as of 1st of March, which to me implies not taking into account events subsequent to 1st of March.
Thank you. I'm going to ask now a few questions to both experts. So, I mean, obviously, given the time limitations, I do not have time to go through each and every point of disagreement. So I will ask you about a few of them. First one, Mr. Potter, you mentioned in section 3.2 of the joint report, you refer to the loan agreements entered into between Plummet and the Gorbo Bank. And you consider, if I sum up your position, that they have no bearing on the cash flow in the actual scenario. Is that a correct summary of your position on the relevance of the loan agreements?
I think my position on this is that there is no clear commercial reason for Gorbo Landsbank to attempt to seize the refinery, a project with a capital outlay of 3.5 billion in connection with loans of around about 60 million. To do so would, absent any other information, likely reduce their chances of recovering those loans.
Yes, I'm going to that point, coming to that point in 1 minute, but as a first point, like your overall conclusion on these loans is that they have no bearing on the cash flows in the actual scenario. Is that correct?
I don't think I've said that in the joint statement.
Will you consider them relevant or not?
I don't consider them relevant to the issue of projecting those cash flows in terms of what the cash flow should be in individual years. I understand the argument that's being made by the claimant or on the claimant's behalf that under those agreements, potentially the refinery could be seized. I just don't see that as a likely scenario.
So, I mean, you would agree with me whether or not the provisions of this agreement would allow for the seizure or not is a legal question on which you are not opining, I assume.
The enforceability of the loan agreements, I'm not giving a legal opinion on that.
Yes. So let's assume, I'm not asking you to agree with me, but let's assume under these loan agreements, there was a default by Plummet on covenants, which triggered the right of seizure of the
I think we may have some technical difficulties. We have lost Ms. Dulac, but we will then allow Mr. Henderson to ask his questions while we wait for Ms. Dulac to rejoin us.
Thank you, Mr. President. Mr. Nicholson, Mr. Potter, we're quite short of time this afternoon. So what I'm going to do is ask Mr. Nicholson a series of questions, and then, Mr. President, would you like me to return the floor to Mr. Dulac?
Yeah, well, Ms. Dulac, I think you've almost come up to your time in any event. Perhaps we'll give you another 2 minutes just to finish your questions, and then we'll turn to Mr. Henderson.
Thank you. Hopefully it won't disconnect again. That wasn't intentional. So Mr. Potter, going back to the law, so let's assume, I'm not asking you to agree with me. Let's assume, as a legal matter, Plummet breached some covenants, it triggered a right of seizure by the bank of the refinery and smelter. If such was the case, would it have an impact on your assessment of damages? Would it be relevant this time?
I think we'd need to look at what the likely outcome is of that, and would that really result in the termination of the project and the loss of all revenues going forward to the claimant, which is how the claim is currently calculated by the claimant. I don't think that's a likely outcome.
No matter how unlikely, it will become relevant and could potentially have an impact.
If it's so unlikely as to not be there to be a serious prospect of that happening, it wouldn't be relevant to the calculation, no.
What if it's likely?
If the probability of Gorbo Landsbank exercising their rights of seizure were so small as to not be at all likely to occur, then no, that wouldn't factor into the loss calculation.
Yes, my question was, what if it was likely? You may not agree it would be. What if it was likely?
Then that would factor into the loss calculation.
What if it... Thank you. I have no further question.
Thank you, Ms. Chula.
I have no further question.
Mr. Henderson.
Thank you, sir. Gentlemen, Mr. Potter, Mr. Nicholson, I was saying that I'll have a short series of questions for Mr. Nicholson, and then as this is a hot tub scenario, I'll ask Mr. Potter to comment immediately on Mr. Nicholson's responses so that the tribunal can hear in real time the benefit of both of your views on these issues. Mr. Nicholson, your report assumes that the claimant's actual future cash flow will be zero, doesn't it? It will have no future cash flow.
That's correct.
And you say that because you assume that the claimant will be out of business. You assume that it's breached its banking covenants, that the bank will step in and seize its assets. That's your assumption, your hypothesis, am I right?
That's right, as summarized at point 3.2 in table 2.
Yes.
Which I assume you're looking at, yes.
Thank you. And just to be clear, this is simply your assumption, isn't it? You haven't personally reviewed the claimant's loan documents, haven't you? Have you? You haven't personally assessed whether it has in fact breached its banking covenants.
No, that's right. I've been instructed to assume that the claimant has breached its covenants and that Gorbo Landsbank has the right to seize the refinery and smelter.
Right. And similarly, you haven't investigated for yourself whether the bank is actually likely to step in and seize the assets, have you? You haven't looked into the nature of the relationship between the claimant and its bank.
I haven't in any detail, no. Beyond this instruction that the claimant has breached its covenant. So I don't know. I don't think any of us know if there's a wider relationship between Gorbo Landsbank and the claimant, for example, that might be relevant here.
Right. So maybe at the risk of belaboring the point, but nonetheless, you were told by the claimant's lawyers to assume these facts. You were told to assume that the bank would seize the assets. You were told to set the future cash flow at zero as a result of that. Is that correct?
That is mostly correct. I was told that Gorbo Landsbank was entitled to seize the refinery and smelter, which would deprive the claimant of its entire investment.
And Mr. Nicholson, have you checked whether the bank has actually seized the assets in the last 6 months?
I actually don't know whether it has, so no.
You haven't checked. I see. Now, you explained earlier that you haven't, in fact, considered anything that's happened in the last 6 months. For example, you haven't taken account of the recent steep fall in steel prices, have you? There's been a big drop in steel prices since the start of the pandemic. That's clear on the public data, but that's not part of your report, is it? You only look at steel prices from before the pandemic, correct?
Yes, that's right. As I explained a few minutes ago, I'm assessing the value of the business as it would have been on the 1st of March 2020. So that rules out me looking at anything that's happened since that date.
And I suppose for the same reason, that's why you haven't looked at the actual decline that the claimant has experienced in sales volumes since March 2020. That would be out of scope for your assumptions too, correct?
Yes, exactly.
And you haven't taken account of the lockdown that was in fact experienced at the end of March 2020 and how that impacted on the claimant's operations, have you? That's not in your report either.
That's correct. Yep. Same for the same reason.
And also for the same reason, there's nothing in your report about supply chain disruptions or the delays in obtaining specialist spare parts. Although in fact, the tribunal's own appointed expert says that this has been a very significant factor. But again, for the same reason, that's out of your report as well. Am I correct?
Well, partly for that reason, and partly, at least in relation to the spare parts, that relates to the mining operation that the respondent was undertaking and not the smelting and refining operation that the claimant was undertaking. As I'm assessing the claimant's losses here, the absence of spare parts aren't directly relevant to the loss assessment that I'm making.
I see. So, Mr. Nicholson, let's just back up here, shall we? Let's think about your conclusions. You have assumed that the claimant's future cash flow is zero. Without trying to assess that for yourself, you made that assumption because that's what the claimant's lawyers told you to do. You also haven't checked what the bank actually did, whether it has in fact seized the assets, whether the business is actually still ongoing. You didn't think that was relevant. You also haven't considered the fall in steel prices, the drop in sales volumes, the disruption to supply chains. You haven't even considered the effect of the lockdown, although that did gravely disrupt the claimant's operations. None of those things are taken into account in your report, are they?
That's right, because if the tribunal agrees with the claimant that the relevant date for assessing losses is 1st of March, then none of that is relevant.
So, Mr. Nicholson, your report's fantasy, isn't it? It is totally disconnected from reality because you have not made any single attempt to assess the real world impact of COVID-19. This report, Mr. Nicholson, this is hypothetical, unrealistically hypothetical at that. There is nothing in this report that the tribunal can rely on as a realistic, real-world estimate of the claimant's true losses, is there?
I'm sorry, Mr. Henderson, I have to reject that view. It's an entirely realistic assessment of the value of this business as it was on the 1st of March 2020.
It's a realistic assessment on the basis of a series of hypotheses and assumptions, none of which are borne out by the facts. That would be a fair summary.
That's necessarily the case when one's working with expectations. Of course, the real world turns out differently from expectations, and valuers work with expectations all the time and see facts turn out more favorably or less favorably all the time. I just come back to the main point, which is assessing losses as the 1st of March implies disregarding subsequent events.
Mr. Henderson, I hate to cut you off in the thrust of cross-examination. Have you finished, Ms. Henderson?
I was, if the tribunal has an indulgence, given the hot tub situation, I was going to ask Mr. Potter if he wants to take a minute to come back on that, but I'm in the tribunal's hands. I've finished my cross.
I was going to say that we'll give you a minute to wrap up.
I would only come back on one point, and that is a point that Mr. Nicholson made, that if he were assessing the value of the business at that earlier date, and that's how you get into this blinkered perspective of only taking into account facts at that date. If you were doing a business valuation of that date, I think we'd probably be on the same page. But I think where we're assessing losses, and we're assessing losses today as at an earlier date, there's nothing to stop us making use of the information available to us now to come up with an accurate assessment of that loss.
Thank you, Mr. President. That completes my portion.
Thank you very much, Mr. Henderson. Well, before we release the expert witnesses, I ask Mr. Celniker or Mr. Kim, you have any questions?
Yes, I have a few. I need some clarification. As to Mr. Nicholson, as to the forecast steel prices, I see that you compared with the middle March rather than Castelia, and the basis of that is there's a similar population similar economic stage of development and similar size and population, domestic market, and a industry contribution, right?
That's correct, yes.
But you probably agree that even though such a things are same, but country might have different policies in this COVID-19 situation, that different regulations or different a infection rate or death rate. But you haven't considered have you checked such a fact in your when you make your report?
Well, it's the same point as I was just making to Mr. Henderson, which is that the response of the benchmark country Middlemarch is to the COVID situation is not relevant to my assessment because that all happened after the 1st of March 2020.
Okay. In case of Porter, Mr. Porter, I have you actually assessed the compare the country with the infection rate and death rate, and the travel restrictions, those things happens, but you have you considered that different aspect like economic size or a stage of economic development in your assessment?
I've focused on the impact of the pandemic because that was the large event that occurred during this time. I think it's reasonable when looking for a benchmark country that was affected by the pandemic, then you're trying to assess the impact of the pandemic, to find a benchmark country that was affected similarly, that adopted similar policies for a similar time. So that I think should be the key factor if you're able to use hindsight.
Okay, thank you. One more just point.
Mr. Kim, unfortunately, the parties have put us on a very tight chess clock, including the tribunal. So I think Mr. Celniker had a question. One question, Mr. Celniker.
Yeah, I had just one question for Mr. Potter, and then hopefully Mr. Nicholson can comment. In 3.3, now moving beyond the zero scenario and looking at a but-for forecast of sales that you've given, you've also made a number of assumptions about the price. And the one I want to ask you about is the last one. You agree with the claimant that most of their supplies are their long-term take-or-pay agreements with fixed prices. Do you not?
I do, yeah.
Yeah. So when you say, I think, well, let me ask you this. Don't you think that you're using a little bit strong language to say that it's likely that the customers are going to require the prices to be renegotiated? I mean, I guess my question is, why would you assume that the claimant would agree to any renegotiation when they could simply assert a breach of contract claim for the full price?
I think in situations like this, where everyone's facing an unusual scenario, something that hadn't been anticipated, and where you have long-standing contracts and relationships in place, it's very common for parties to accommodate one another in order to protect the relationship in the long term, and in some cases ensure the survival of their counterparties.
Mr. Nicholson, do you have a comment on that?
I think that does happen, but we have no evidence on that, so it does seem a somewhat speculative position of Mr. Potter's on that point.
Thank you.
Thank you very much, Mr. Nicholson and Mr. Potter, for your evidence. We can now release you. Thank you.
Thank you.
We will now proceed to hear the evidence of Mr. Andrew Webb.
I'm sorry, Chairman, are you releasing the other experts?
Yes, we have released Mr. Nicholson and Mr. Potter. Mr. Webb, thank you for assisting the tribunal with your evidence. Before the council put questions to you, I'll invite you to summarize the evidence you've given to us very briefly in a minute and a half, if you can, please.
Thank you, Mr. President. I was invited to examine the consequences of the pandemic on iron ore operations globally. I was not within that scope looking at the factual position at Kingdom Mining. I will summarize the findings over 5 areas, drawing on page 11 of my report, but I will speak to it for those who don't have it in front of them. The first area I looked at was around government and workforce. Many governments globally, covering the majority of iron ore production, took the view that iron ore production was an essential industry, and subject to the implementation of safety measures, they wished it to continue. Although certain governments, and I've drawn out some examples in my report, mandated workforce reductions or localized short-term lockdowns, typically up to 21 days, and required the employers to focus on cutting down their workforce to essential functions only, and relying on the physical isolation of the workforce, which is quite usual at an iron ore operation and an iron ore mine. And generally the workforce, and particularly the unions, were flexible because they wished to see continued employment, even where they expressed misgivings as to changes in shift pattern and technology. The second area I looked at, which had a larger impact on the red, amber, green simplified summary, was around supply chains. Globally, the industry has moved more to just-in-time inventory, which exposes it to greater disruption. And there was some disruption around specialist spares. Certainly, commentators were saying by March, April, they were seeing tightness in key markets around items such as tyres. The impact on any particular company depended on their strategic stocks of spares, which typically is related to their remoteness and their management of usual business risks, along with their maintenance regimes, predictive maintenance, etc., and of course the age of their equipment and its propensity to need spares. The third area I looked at was transport and logistics. Iron ore relies hugely on infrastructure. However, globally, there were no significant rail interruptions and very few port interruptions for bulk cargoes, including iron ore. There were some government mandated ones in South Africa around Sardana Bay. There were some interruptions in India related to workforce, but there were no port interruptions in China, for example, in terms of imports of iron ore for steel production. The fourth and penultimate area was around demand and pricing, where in summary, for the first half of 2020, the reduction in supply was broadly balanced by a reduction in demand. And although pricing could be argued to be driven by sentiment, broadly across the piece, whilst it was volatile within a tight range, it essentially ended up slightly higher than it was at the beginning for iron ore, unlike steel, which has been stated earlier, did suffer a reduction. And the last area I touched on in this very brief summary was around the obligation, the ability of iron ore producers to meet their contractual obligations. And I would summarize that by saying the bulk of the world's production continued unabated, uninterrupted. There was equally on the demand side, there was no significant incidents of China steel makers calling force majeure on their contracts, despite offer from government to provide certificates where they had international contracts. There was some force majeure export from India due to their inability to export, and some small mines were constrained by their equipment availability and supply chains and ended up reducing production. That would be my very short summary, Mr. President.
Thank you very much. We will now proceed to examination by counsel. We'll begin with Ms. Dulac.
Thank you. In the interest of time, I'll just ask you a few questions. The first one relates to slide 5 of your report, in which you have a list of six countries, and you give an overview of the measures adopted by governments in these 6 countries. you mentioned like iron ore is an essential industry. As production in any of these 6 countries stopped for 3 months, from March to March, April, May?
Within those 6 examples, the longest lockdown was 21 days in Cordinia, and a similar length, although subsequently curtailed reduction in Samavia, which, whilst it cut short of 21 days, mandated that mines only produce at 50% of capacity for the remainder of the 21 days. So none of those 6 examples continued for 3 months.
Yes, and these 21 days, the 2 examples of 21 days lockdown was it in March 2020?
Correct, overlapping, I think, into April, although I would have to check that.
Yes, but nothing past April?
Not in those 6 examples.
Yeah, nothing in June?
As far as I'm aware, no global lockdowns impacted iron ore production in June.
Thank you. And just briefly, a few questions on the question on the spare parts, which has been heavily relied on by the respondent as a ground for its force majeure argument, as I'm sure you're aware. So you give an overall assessment in the industry of the question, the issue with spare parts, but basically to assess the impact of on a given miner of the supply chain, you would need to know what inventory it had, correct? Which is going to vary from one company to another.
Inventory and maintenance practices probably make the largest impact on short-term requirements of spare parts, yes.
Yes. And you do also need to look at where there are alternatives, I mean, more costly alternatives, but where there are alternatives to actually get these spare parts at a higher cost.
Indeed, and that depends obviously on the type of equipment we're talking about and whether there are, as for tyres, alternatives, or as for different specific parts, perhaps no alternatives.
Thank you. And one last question. In your opinion, would it be common for spare parts, missing spare parts, within a few weeks to cause the entire cessation of activities, an impossibility to produce?
I think that depends on the nature of the production equipment in use. If, for example, one standardized sort of front-end loader was being used in the pit, which all relied on one part, and that part became unavailable, and the maintenance regime was such that failed during that period on multiple pieces of equipment, then it could happen. Obviously, mining companies tend to try and arrange their maintenance regimes where you do not see widespread failures, regardless of the supply chain.
Last question, would you expect a diligent mining company to either have spare parts or a lead time proper maintenance for critical parts, which if they were missing, would cause a cessation of activity?
I do think that is a global problem because of the move to just-in-time supplies, that now post-pandemic, the industry is re-examining its reliance on those supply chains. So I do think that's an issue which has been revealed by the pandemic, and it's not just a question of the diligence of the company at the time.
Thank you. No further question.
Thank you. Mr. Henderson.
Thank you, sir. Mr. Webb, I've received a message from the President asking us to be very brief in this cross-examination. I understand that the Tribunal wants to get to cocktails. From what I know of them, that's not a surprise. So bear with me and cooperate with me, if you would, while we speed through some points quite quickly. Your report analyses the impact of the pandemic on working practices and iron ore mining operations in 6 countries, correct? And you list them in your report.
I looked at more than 6. I just chose those 6 as they cover the bulk of the world's production.
Thank you. Now, those 6, Arundel, Samavia, Bartovia, and so forth, not one of those 6 is actually the Republic of War and Peace, which is the place where this mining operation is based. Is that correct?
That is demonstrably correct.
Thank you. Now, also, when we look at your experience and qualifications on page 3 of your presentation, there's no reference there to any prior experience of war and peace either, is there?
It is a country which I have not had the pleasure of visiting.
I see. Now, on page 5 of your presentation, you say this, quote, "How governments responded in relation to mining operations varies around the world," close quote. And then you set out a table with the government response to the impact of the pandemic in relation to mining from the 6 countries that you did choose to quote from. And we see in that table that even between those 6 countries, there is a significant variation. Is that a fair assessment?
I think that is a fair assessment. In my mind, it varied according to the geographic risks to the workforce.
Thank you. Now, you give us one example in your report of the way that the impact of the pandemic in the Republic of War and Peace is in fact directly contrary to your own experience and the conclusions of your study. This is on page 6, where you say, "I am not aware of any locations where negotiations with unions were protracted and caused disruption to production," close quote. And then almost immediately you go on to admit that that is in fact exactly what happened in the Republic of War and Peace. So the position in the Republic of War and Peace appears to be significantly different from the conclusions you drew from your review, correct?
From my inquiries of the negotiations with unions across the other countries, that is correct.
Right. So Mr. Webb, I will be saying to the tribunal that your report tells us absolutely nothing about the impact of the pandemic in War and Peace. It doesn't even discuss War and Peace. It isn't even a reliable indicator for War and Peace because you haven't looked at any data for War and Peace. You haven't got any experience of War and Peace. And the one thing that you refer to in War and Peace is how that it's different from any of your experience and your conclusions. So just to be clear, Mr. Webb, I'm not challenging the conclusions in your report. I'm just saying that they're irrelevant to this specific dispute, which is to do with another and different country. And I think, Mr. Webb, as an independent expert, you would have to agree with that. I invite you to do so.
I think the reason for the report was to provide the context, both in relation to the 95% of global production covered by the report, as that may impact everything from valuation to causation. But I completely accept that no part of our report covered the Republic of War and Peace.
Thank you, Mr. Webb.
Thank you for your evidence, Mr. Webb.
Thank you, President.
Right, I think in the interest of time, we should move on. We'll release Mr. Webb.
I have one question.
One question. All right, Mr. Celniker, one question. Quick question, please.
I'm just interested in page 7 of your report. You say that many large ore mines retain critical spares on site, I guess to address the risk of unanticipated supply chain disruptions. Is that correct?
Correct, particularly where those sites are remote, as many iron ore mines tend to be.
So some do and some don't. That's the.
I think all do to greater or lesser extent.
Okay. So the prudent approach is to have critical replacement parts on hand.
That will be the case, although not necessarily sufficient critical parts to be able to use, to fix all bits of equipment that may fail.
Okay, thank you.
Right. Thank you, Mr. Celniker. Thank you for your evidence. You are released.
Thank you.
Right. We shall now proceed to closing arguments. I understand we're going to hear from the respondent first and followed by the claimant. Given that we've already run past the chess clock agreed by the parties, we'll ask the counsel to limit themselves to 5 minutes in their closing.
Thank you, Mr. President. Thank you, members of the tribunal. 5 minutes is a luxury. I thought I had 4. Members of the tribunal, you have to determine a specific issue of liability, which is whether the respondent can rely on the force majeure clause in the contract. If you find that the facts of the case fall within the scope of that clause, then the claims will fail and the case must be dismissed. That is the respondent's primary position. But if you find against the respondent, if this is not a case of force majeure, then the respondent may be in breach of contract and you must consider the quantum of damages. And here, the respondent's position is that the report produced by the claimant has grossly exaggerated the assessment of likely losses. And perhaps I may say here that that is to me an extraordinary surprise given Mr. Nicholson's usually exemplary standards as an expert in arbitration in Singapore. Let me briefly address you on both aspects of this case. Very briefly in relation to force majeure, because my colleague and co-counsel, Mr. Yeat, has addressed you fully on that. The short point is that the clause in this contract is perfectly clear, it's broad, it's expansive, and it is certainly wide enough to cover the impact of the pandemic. But if you disagree with me, if you decide that there was a breach of contract, then you have to consider what damages may be due. And here we say the claimant's expert evidence is miserably deficient. The experts agree that damages must reflect the difference between the actual cash flow in the future in the light of events which have occurred and the but-for scenario, but the claimant has manipulated both of those calculations. On the one hand, they have massively understated future actual revenues. In fact, they've set them at zero on the basis of untested, unverified assumptions. On the other hand, they have massively overstated forecasts of revenue in the but-for scenario by simply ignoring, failing to consider any single real-world factor that would have affected the business of the claimants. Now, by understating one part of the equation and overstating the other part of the equation, the claimants massively exaggerate the delta between those two factors, and that, members of the tribunal, renders their evidence absolutely unreliable. It must be disregarded. And without that evidence, the claimants have simply failed to prove the quantum of damage. Lastly, perhaps I should say that with all due respect to the tribunal's expert, Mr. Webb, his report is simply irrelevant to this dispute. He hasn't studied the impact of the pandemic on war and peace. In fact, he admits that events in war and peace actually contradict his findings from other countries. So I have to invite you to pick up Mr. Webb's report and throw it away, because it really has no value whatsoever for your deliberations. Members of the tribunal, in the circumstances, those are my submissions on behalf of the respondent. Thank you. I'll be glad to answer any questions.
Thank you very much, Mr. Henderson. Well, let's hear from Ms. Dulac.
Thank you, Mr. President. So in this interest of time, I mean, the starting point really, and we've heard what is a false debate about the force majeure clause. The response line of argument seems to be, well, if you fall within the list, which was taken out of the draft, if you have a epidemic, that was a word used, then you have the force majeure is triggered. That's absolutely not the case. And it doesn't matter whether there is a list or not. Even if we were under the original clause with a list, the event has to meet the conditions for force majeure in the clause. And these elements remain unchanged in the draft. It has to be beyond the control of the respondent. There shouldn't be negligence or fault on the part of the respondent. And there needs to be causation. The event needs to make the performance of the contract impossible. And the clause also requires the respondent to make its best effort. We haven't heard anything today from Respondents' Counsel trying to particularize for each of the three alleged events of force majeure how these elements in the clause are met. And that alone warrants the rejection of the force majeure claim. The burden was on the respondent to prove these elements. It doesn't even try to. So just alleging epidemic COVID-19 equal, I don't have to perform the contract, is absolutely not what is provided for in the force majeure clause, whether the one signed, which is the one you should look at, or the one which was negotiated at an earlier point. And very briefly, really to address the three elements. I mean, the fact that the respondent is relying on three alleged events in force majeure, separate ones itself, is quite telling, because if you have 3 reasons for not performing, the chances are you don't have a single one. And if you look at these reasons, 2 of them, one was in February 2020, the issues with the labor union. The other one, the spare parts, we don't even know. The respondent has explained to us what it is missing, for what duration, what the impact is, what it had tried or not tried to do to procure alternative spare parts, even at a higher cost. There is just no particularization of what exactly the spare part impact is. And the lockdown was lifted in April, and production could restart in April. So then we have a force majeure declaration in June for all these past events, where there is absolutely no evidence that there is any possibility for the respondent, whether before June or from June onwards, because the respondent is still not complying with its obligation, because of any of these elements, let alone because of COVID-19 taken as some vague concept to excuse performance. And on the damages, very briefly, I think the respondent's expert, there is a difference obviously on insight, and it will be for the tribunal to make a decision. Our expert has made its point as to how the reasonable way would be not to take into consideration an insight. But in any event, the approach of the response expert has been very truncated, disregarding elements specific, and you've heard about the long-term supply contract at a fixed price entered into by the claimants. That hasn't been taken into account. The infrastructure plan in response to COVID-19 taken by War and Peace, that hasn't been taken into account. So it's a very partial view, and we believe leads to a gross underestimation of damages in this case. Thank you. Leads to a gross underestimation of damages in this case. Thank you.
Thank you, Ms. Tulak. Tribunal thanks counsel for its assistance and also for keeping to time as best as we all can. The tribunal will now adjourn for deliberations, and it just remains for me to close this hearing. Thank you very much.
Thank you all to all the speakers for such an exciting session. This concludes the virtual hearing demonstration, and we have come to the end of the SIAC Virtual Congress 2020. Once again, we would like to thank you for attending this year's virtual Congress.